So this class is going to be our last for the moment on the powers of Congress, on the enumerated powers of Congress. Given the section that I added to the syllabus, we will eventually come back to Congress's powers under the 14th Amendment. But this will be the last section on, or the last class on Congress's powers under the original unamended Constitution, under Article 1, or we did look at the Article 4 Property Clause last class. So the taxing and spending powers, if you'll note, the book has them separate and apart from Chapter 4, where we looked at most of Congress's powers, in particular the regulatory powers, as the book calls them, the Commerce Clause and Necessary and Proper Clause. So I will post this as a PDF, this chart that I have here. But let me introduce it, and then I think I'll close with it as well. It looks complex, but one goal of yours should be to try to understand it. You can rearrange it if you want. Eventually, we should add the 14th Amendment powers as well. But the idea here, so in the left-hand column, we have all of Congress's powers that we've studied up through this class, the Commerce Clause being the one that we've studied in most detail. And in the second column, I have cases that exemplify valid uses of those powers. So lots of Commerce Clause cases there where the court upheld Congress's use of the Commerce Clause. Then in the third column, which is subdivided into two columns, but if you look at it as one column, it's headed limitations on the powers. So those would be cases where the court has found that although Congress attempted to use the power listed in the first column, it was invalid. It was an unconstitutional use of that power. So why the subdivision? Well, the first subcolumn I have listed as text-based limitations. So these would be instances where the court found that, in fact, Congress was not regulating what it said it was regulating. So think of Lopez and Morrison. The court found that Congress was not, in fact, regulating commerce. Congress said it was regulating commerce because it used its Commerce Clause power, but the court found, no, you weren't actually regulating commerce. The second subcolumn there, the federalism-based limitations on power, are those cases that we've looked at starting the class just before break, Garcia, which I have as a valid Commerce Clause case, and then the cases that we looked at with this week's Monday class, New York, Prince, Murphy. So these would be cases where the court says, yes, you are regulating commerce, but there's another reason why the statute is constitutionally invalid, and this is where the court gave a number of different explanations. It's a structural reason, or it's a 10th Amendment reason. It's essentially a federalism-based reason. I think I also called it in class the last time we met a non-textual or an external reason. So you could look at the text-based column as being internal reasons. The regulation isn't a valid regulation of the thing that Congress is pointing to in the text of the Constitution. This is not a regulation of commerce. This is not, if there was something in the necessary and proper category, this was not necessary and proper. And as we'll see today, the court will say that this is not a regulation of spending. This is not a regulation of taxing. And in the second column, the federalism-based column, the court is saying, no, this is a regulation of commerce, but there's another reason. There's an external reason why it's unconstitutional. So that explains the columns there. The rows are obviously the powers, but if you'll notice, there's a bigger subdivision between the rows, regulatory and non-regulatory. So thus far, all of the powers that we've looked at have been regulatory powers. Today, the spending power and the taxing power are going to be under the heading non-regulatory power. Keep that in mind, because that's very important. It's very important in particular for that second column under the limit, that second subcolumn under the limitations category. That's going to be the reason why the federalism-based limits don't apply to these two powers, because The regulatory powers directly regulate individual behavior. The non-regulatory powers do not, according to the court. And we'll see what the court means by that as we look at these cases. So both the taxing and the spending power come from this single clause. It's the very first power listed in Article 1, Section 8. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. So very clearly we have a taxing authority here. And as the book points out, and you see an excerpt there from a case called Butler from 1936, pages 477 through 78, there was disagreement amongst the framers, in particular amongst Madison and Hamilton, as to the extent of Congress's taxing power. Was the taxing power limited to taxing in furtherance of the other powers listed? So could Congress tax only if it was doing one of the things listed in clauses 2 through 18? Could it only tax if it was trying to establish a post office? Could it only tax in order to fund the Army and the Navy? Or was taxing an independent power, and Congress could tax for whatever reasons it wanted to? Madison thought it was limited to being used in furtherance of the other powers. Hamilton thought it was a freestanding power. And as the court explains in this Butler case, the court long ago sided with Hamilton, that the taxing power is an independent, freestanding power. It doesn't have to be used in conjunction with one of Congress's other enumerated powers. What we also learn from that Butler case, though, and notice that case is from 1936, and that's important because, as we know, 1937, which the main case comes from, was a big year in constitutional history, in particular for Congress's powers. That's the year of the so-called switch in time. That's the year that the court stops invalidating Franklin Roosevelt's New Deal programs and starts upholding them. You'll recall the famous 1937 Commerce Clause case was NLRB versus Jones and Laughlin. And Sunzinski is the equivalent of that upholding of federal power for the taxing clause. One way that you can see the difference between the pre-1937 formality and the post-1937 functionality is in this difference between taxation and regulation. So recall that one of the court's tactics pre-1937 was to say that what Congress was doing wasn't regulating commerce, but was regulating manufacture. And so it set up that duality between commerce and manufacture. Or Congress wasn't regulating commerce, Congress was trying to prohibit commerce. And it set up that duality between regulation and prohibition. Well, the court did the same thing with the taxing clause. The court would say that wasn't taxation, that was regulation, and therefore Congress couldn't do it. And after 1937, or in 1937, the court abandons that duality, just like they abandoned that dualism in the Commerce Clause realm in Jones and Laughlin. But another one of those dualisms that the court had set up pre-1937 was a distinction between a tax and a penalty. And one would have thought that dualism died in 1937 as well, but it gets resurrected in the healthcare cases in 2012 by the Chief Justice in his opinion, where he upholds the individual mandate as a tax. So we'll have to revisit that distinction in just a moment. But let's look at the 1937 case, the Sunzinski case, for some of these important New Deal era holdings. So Congress passes this act in 1934, the National Firearms Act, which requires a $200 license fee for manufacturers and dealers and per gun transfer. So several taxes in order to get a gun from the manufacturer to the eventual purchaser. Now, if you look at the language of the statute at the top of page 479, it says that the term firearm is defined as meaning a shotgun or a rifle having a barrel less than 18 inches in length. So, what is this referring to? Well, this is referring to sawed-off shotguns and rifles. Right. This is the era. This is the era of gangsters, and Congress is trying to. It's clear that Congress is trying to penalize these the commerce in these sorts of things, the transfer of these sorts of things. So, what is the petitioner's claim? His claim is, again, and his claim would, very rational claim, given that this is 1937 and up to this point the court has been striking down federal legislation based on these dualisms. His claim is that the law is attempting to regulate behavior. In particular, it's trying to suppress traffic in guns rather than tax for revenue purposes. So his claim is that Congress's real purpose here is to stop sales of sawed-off shotguns. And again, remember, before 1937, Congress had a hard time getting its Commerce Clause legislation approved by the Supreme Court. So one way around it might have been to try to tax something, try to tax something so high that people would be dissuaded from doing it if the court said Congress couldn't actually just outright prohibit someone from doing it. And there you start to see the distinction between regulatory and non-regulatory. So that's the petitioner's claim, that this isn't really a tax, it's an attempted regulation. And what is the evidence of that? Well, the petitioner says, look at the tax. It really has a penal type of character. And you see this argued in the first full paragraph on page 479. Right? And to establish its penal character, the petitioner here, relies on the amounts of the tax imposed and the fact that they're imposed at three different steps. So the cumulative effect is said to be prohibitive in effect. And to disclose an unmistakable legislative purpose to regulate rather than to tax. Right? But the court finds that these multiple taxes aren't prohibitive. They're not so high as to make it practically impossible to purchase one of these guns. And most importantly, the court rejects this dualism. Just as the court eventually rejects the distinction between manufacture and commerce, the court here rejects the distinction between regulation and taxation for purposes of invalidating something as not a tax. Because the court recognizes that every tax, as the court says, is in some measure regulatory. What does that mean? Well, that means that every tax has some effect on how people might go about their daily business. If something is taxed at a certain amount, the purchaser is going to think twice about buying it, no matter what the amount is. So a tax is going to affect consumer behavior at any percentage. So what about the argument that even if it's not so prohibitory as to be tantamount to a regulation, what about the argument, but Congress's motive really wasn't to tax, it really wasn't to raise revenue. Congress's motive was to try to dissuade individuals from purchasing these sawed-off shotguns. So Congress's motive was highly regulatory. Well, the court says that, and you'll note that they say the same thing in the Commerce Clause cases, but it's worth looking at here. Inquiry into the hidden motives which may move Congress to exercise a power constitutionally conferred upon it is beyond the competency of the courts. So, 1937, the court says, doesn't matter what the real reason, to the extent there is a real reason for why Congress does something, it doesn't matter what the real reason is, so long as Congress meets the formalities of the power that it's exercising, the statute is constitutional. And I would urge you to go back to the Darby case. If you go back to page 292 in the book, you can see the court saying the same thing with respect to the Commerce Clause. Only a few years later, Darby is 1941. And again, middle of page 292, you can see the motive and purpose are irrelevant to the constitutionality of a statute. So if the court rejects that distinction between a statute that is a tax and a statute that is an attempt at regulation, what about this other distinction that I mentioned early on, this distinction between a tax and a penalty, which the court resurrects in 2012? So how does this distinction come about? So it comes about in this case called Bailey versus Drexel Furniture, also known as the child labor tax case. This case is from 1922, I believe, and so it's definitely a pre-1937 case. How did this case come about? So Hammer versus Dagenhart, I know I talked about in the earlier recorded lectures in the Commerce Clause. This was one of the cases this is the case that gets explicitly reversed in Darby. This case held, so Hammer versus Dagenhart, Congress attempted to prohibit the shipment in interstate commerce of goods made by child labor. And remember, the court there said that that was unconstitutional because the making of the goods is manufacture, not commerce, and also prohibiting shipment is prohibition, not regulation. And just for good measure, the court said the motive of Congress seems to be to regulate child labor, not to regulate interstate commerce. All things that the court eventually rejects in Darby. Right? So Congress knows that it can't outright prohibit child labor through the Commerce Clause. That would be a regulatory power. So Congress thinks it will try its taxing power. So what if it does tax goods made with child labor at a very high rate, such that people would prefer not to buy goods made with child labor? Well, the court strikes that down in the Bailey versus Drexel Furniture case. And what the court says is that lots of things that will eventually be rejected. The court says that Congress was really trying to regulate child labor. The court said explicitly, if you look at Chief Justice Taft's opinion, he says, we know what Congress was trying to do. We're not blind, and he actually says that. He says, we're not blind to what Congress is trying to do. They're trying to do the same thing that we told them they couldn't do in Hammer, just instead of through the Commerce Clause, they're trying to do it through the Taxing Clause, and therefore we have to invalidate this statute as well. And one of the dualisms that Taft set up here was in explaining that the tax was actually more of a penalty than a tax. So what turns something from a tax into a penalty? Well, he said there are three factors that we look to. We look at the relative burden on the individual or the entity that's taxed. And here it seemed incredibly high, right, leading to the thought that what Congress was really trying to do was penalize child labor. You look for the presence or the absence of a scienter requirement, and you might remember that term from criminal law. Scienter means knowledge. So does the tax only kick in when someone has knowledge of their actions? Because if that's the case, then it looks like you're taxing knowledge of wrongdoing. So does the statute only kick in? Does the tax only kick in when you know that you're purchasing something made with child labor? If so, that looks more like a penalty, right? Imagine that Congress enacts a statute that says you are only taxed, that there's an iPhone tax or there's a cell phone tax. But it gets doubled if you know that the product you're buying was made with child labor. Then it looks like Congress is really attempting to do more than just raise revenue. It looks like Congress is attempting to affect the underlying thing that it's taxing, which is child labor. So the absence of a scienter requirement is more on the tax side. The presence looks more like a penalty. And then you look at the federal agency responsible for enforcement. Right? Is it one of the regular law enforcement agencies, or is it the taxing authority? Right? So all of these factors get put into the determination of whether something is a tax or a penalty. So looking at the note, and all we have is a note, page 480 to 481, on the healthcare cases. So this is, and we talked about these the last week that we met. We explained why the court was unable to reach a conclusion on the Commerce Clause holding, whether the requirement that you buy health insurance or the requirement that you have health insurance, whether it's through your employer or through individual purchase or through ultimately a tax, if you didn't have insurance, why that was constitutional. And the court couldn't agree that that was constitutional because Congress was merely regulating commerce. But 5 members of the court do agree that this shared responsibility payment, as it was called in the legislation, could be upheld as a valid tax under the taxing clause. So what does the court look at in making this determination? So the way it worked is there's a new requirement that you have to have insurance. And you might think, well, that looks like a regulation. That looks like Congress forcing you to do something under some sort of penalty. But the court says, no, it looks like an actual tax. Because if you didn't have health insurance, then you could merely pay the tax. Now, a couple of things the court had to overcome. One is that Congress actually described this payment as a penalty for not maintaining minimum essential health care coverage. But the court said that it wasn't going to take Congress at its word, that penalty was more of a political term that was used. And if you look at how the act actually functions, it functions more like a tax. Why is that so? And this is when the Chief Justice brought in those distinctions from Bailey versus Drexel Furniture, or those factors. If you look at how much someone would actually be charged for not having health insurance, it was calculated as a percentage of household income. So it wasn't prohibitive in any sense. And it was subject to a ceiling based on the average annual premium for comparable private health insurance. So it's not as though you were taxed into buying health insurance. It would never be so high that health insurance looked preferable to the tax. Also, it was paid to the IRS with your individual tax return. So if you go back to those Bailey versus Drexel Furniture factors, the authority that collected the tax was the IRS itself. And moreover, the statute said that the IRS cannot use its criminal enforcement mechanisms to collect the payment. So all of these things put together, the court concludes this looks more like a tax than it does a penalty. So although the court invoked that pre-1937 dualism, the invocation of it did not doom the federal statute. And the next slide, I have those conclusions listed there. The tax was not exceedingly burdensome. I guess I didn't mention the second factor there. The individual mandate was not premised upon your knowledge or lack thereof. Everyone owed the tax, whether they had knowledge or not about whether they were covered by health insurance. So what about federalism concerns? So the court does say, they remind us in this healthcare case that the taxing power is greater in some sense than the commerce power. In other words, Congress seems to have more power when it's using one of its non-regulatory powers, but Congress has less control over individual behavior. And this is really where that distinction between the regulatory powers and the non-regulatory powers come from. And this is why. The Chief Justice said that the individual, when it is a tax and not a true regulation, the individual still has the choice to do or not to do the underlying action, so long as he complies with the tax. And he then contrasted this with a statute that would have been enacted under one of Congress's regulatory powers, like the Commerce Clause. So think about it this way. Take one of the Commerce Clause cases that we read. Let's say the Gonzalez versus Raich case. In Raich, remember, people could be arrested for possessing marijuana or growing marijuana because the federal statute, the Controlled Substances Act, which was passed under Congress's commerce power, was regulatory, right? You follow the law or you go to jail. And that's a standard regulatory remedy, right? If you don't follow the law, Congress's remedy is you go to jail. Highly regulatory of individual behavior. How is a taxing power less a lesser power with respect to control of individual behavior? So the Chief Justice says when the choice is not do what we say or go to jail, that gives people a lot more freedom. When the choice is do this and pay a tax, or don't do this and not pay a tax, those choices, those are true choices. And perhaps that choice doesn't seem as clear when we're talking about this particular case, this health insurance case, because the choice is buy health insurance or pay this tax. And the out-of-pocket sum might be nearly the same, right? And so therefore it seems like most people would buy the health insurance because at least you're getting something for your money. You're not just giving money to the IRS. But put that choice in a different situation. Let's say that we're talking not about health insurance, but about something like military service, right? Congress, if it's using its regulatory powers, could say everyone over 18 must enlist in the military for 5 years, right? Or go to jail. That would be a regulatory action. But now imagine Congress exercising that under its taxing power, where Congress says you can serve 5 years in the military, or you can pay a tax of $1,000 over each year for 5 years. The Chief Justice says that gives people a real choice, and that's the distinction between a non-regulatory versus a regulatory action. So, in one sense, then, Congress's power is greater because it can do things under its taxing power that it couldn't necessarily do things under its regulatory power, right? We'll see how that plays out in the spending area as well. There is a dissent in this case. It was the joint dissent that dissented on every aspect, the taxing holding as well as the commerce holding. And Justice Scalia and Justice Kennedy, they claim to have jointly wrote this opinion, although certain parts of it certainly sound like, to me, more like Justice Scalia's writing, especially this part where he says that his objection to it is not that Congress couldn't tax people into buying health care. So he acknowledges this post-1937 transformation in the taxing power. But he says he says that they didn't do that here. And he really objects to the language that Congress used. He says that the tax was framed as a penalty and the court shouldn't overlook Congress's own framing of its own statute. Why does that matter? He focuses a lot on this idea of political accountability, which is an idea that we've seen before. This was at the heart of the New York case, the heart of the Prince case. The idea that Congress sometimes tries to escape political accountability. In New York and Prince, it was by passing off obligations onto state governments. Here, Justice, again, if this was Scalia or whoever of the four who wrote this dissent, they say that Congress can avoid responsibility, political responsibility, by not calling something a tax. They say that for a politician to stand up before the voters and say, I voted for this new tax, that's very politically damaging for them. But that's what a congressman should have to do if he, in fact, votes for a new tax. And so the dissent here, very formalistic. It really seems to turn on the language that Congress used for them. All right, what about the spending power? The spending power is interesting because it's not explicit in the Constitution. It's not explicit in Article 1, Section 8. Instead, the court says that the spending power can be implied from the taxing power. So go back to Article 1, Section 8, Clause 1, and Congress has the power to not only tax, but to pay the debts and provide for the general welfare of the United States. The idea is that For this to have any meaning, for Congress to be able to pay the debts, then it must be able to spend money, right? And to provide for the general welfare, it must be able to spend money in order to do that. And just like the taxing power, the same clause in which this to pay the debts is located, this is not tied to the other enumerated powers. So it's not as though Congress can only spend money in order to fund the armies or in order to fund the post office. Congress can spend money for any purpose so long as it is, and this is where this language of general welfare comes from, so long as Congress can assert that the spending is in furtherance of the general welfare of the United States. And like the taxing power, this power is in a certain sense greater because it's unmoored. It's not tied to any of those other enumerated powers. So the court says, with respect to the spending power, that Congress can do indirectly through mild encouragement what it cannot do directly, like setting a national drinking age. Right? And that will be the next case, South Dakota versus Dole. So we have this case where Congress, in the Highway Act, threatens states with the loss of 5% of their federal highway funds if they do not pass a minimum drinking age of 21. So, is this something that Congress can do? Now, the idea is that Congress likely could not mandate nationwide drinking ages because this doesn't in any way affect interstate commerce. Right? If so, you can imagine the current court, if they had a problem with Congress attempting to regulate the mere possession of a gun in a school, or if Congress couldn't regulate violence against women, then Congress can't regulate the age at which someone drinks alcohol entirely within a state. Right? So if Congress can't directly regulate that aspect, can it indirectly regulate it? Can it offer, as the court says, mild encouragement? And here, the court upholds this this spending power, this deal, you could say, that Congress is trying to strike with the states. So what's the test, or what are the criteria for valid spending clause legislation? In the court here, you do want to know this test fairly well. The court sets out the limits on the spending power in terms of 4 factors. They say that the statute must be in pursuit of the general welfare. Again, that comes from the language of Section 1, Clause 1, or rather Article 1, Section 8, Clause 1. But that's going to be a very subjective standard, and it's unlikely that the court is going to strike something down because it's not in the general welfare. More significant factor here is that the conditions must be unambiguous. So when Congress says to states, do this or lose money, or when Congress waves money in front of states and says, do you want this money? If so, you must do this. The this must be very clear, according to the court. The conditions on the money must be unambiguous. Also, the conditions must relate to a federal interest. So Congress has to explain what the federal government gets out of this deal, or why there is some interest that, although, yes, it's a federal interest that maybe Congress can't get at through its regulatory power, but nevertheless is a federal interest, right? Think back to all the times that the court has said, just because something poses a national problem doesn't mean there's a national solution. Well, this might be one way around that. So long as Congress can say what the national problem is, that will assist in the court upholding it as a valid spending clause statute. And then the fourth is usually not that big of an issue. The states can't be encouraged to do something unconstitutional. So looking at this particular case here then, how does the court go about upholding the drinking age, the national drinking age via the spending clause? What is the interstate problem that requires a national solution? So one of the problems here is that South Dakota has a lower drinking age than neighboring states. So let's say that you are a teenager in Minnesota. Minnesota's drinking age is 21. South Dakota's is 18. You're a 19 or 20-year-old who lives on the Minnesota border. What do you do on weekends? You drive over the border to South Dakota to drink. And then what do you do after you're done? You get in your car and you drive, probably drunk, back across the highway. So this seems to be a national problem. This is a problem where states are causing problems for their fellow states. And because Minnesota has no authority over South Dakota law and vice versa, there seems to be a federal interest here. Right? So that's how the court justifies calling this a interstate problem that requires a national solution. Right. And the court says in the middle of page 483, the goal of the interstate highway system has been frustrated by varying drinking ages among the states. Right. Also, bottom of page 483, you can see where Congress has more leeway with its non-regulatory powers. Right. The constitutional limits on Congress when exercising its spending power are less exacting than those on its authority to regulate directly. Right. So there's another example of the greater, the more expansiveness of Congress's non-regulatory powers. Right. And why are they again, just to emphasize the non-regulatory nature, and here, go back and look at the chart. So spending was one of the ways that the New York case explained Congress could do something other than by commandeering a state legislature. So we know from a case like New York that Congress cannot force South Dakota's legislature to pass a statute saying the minimum drinking age is 21. But through the use of the spending power, and the New York court said this, Congress can achieve that same goal through this mild encouragement. Right? So Congress can't force the state of South Dakota to do this, but they can try to persuade them by offering them money. All right, the Medicaid expansion. So this is yet another part of the Obamacare health care case. So besides mandating individual health insurance, the Affordable Care Act also attempted to expand Medicaid. Medicaid, at the time that the act passed, covered the health care of needy individuals, according to the statute. And it was a sharing program between Congress and the states, with Congress providing for between 50 and 83% of a state's costs. If you look at what percentage of states' budgets were derived from their participation in the Medicaid program, at minimum, the state that got the least amount from Congress, this still amounted to 10% of the state's overall budget. So some states, Medicaid money from the federal government represented a lot more than 10% of their budget. So what Congress did when it passed the Affordable Care Act is it said, we want to expand Medicaid. We want to expand Medicaid to cover all individuals, not just needy individuals, as that had been previously defined in statute, but all individuals under 65 with incomes below 133% of the poverty level. And the statute said, if states don't expand their Medicaid programs to cover this new expanded class of people, then they will lose their Medicaid funding. Because the state's receipt of funding was tied to their participation in this new program. And the court invalidates this statute as being beyond Congress's ability to exercise its spending power. Why? What is the difference between saying you must do this or lose money? Because isn't that exactly what South Dakota upheld? You must set your drinking age at 21 or you're going to lose your highway funds. Here Congress is saying you must expand your Medicaid program or you're going to lose your federal Medicaid funds. Well, the court said that the difference is that this was not mild encouragement, but rather this was what the Chief Justice called a gun to the head. Why? The difference has to do with the percentage of a state's budget that a state would lose by saying no to Congress. Right? If South Dakota had said, no thank you, we'd like to keep our drinking age at 18 and refuse the federal money, this would have been less than 0.5% of South Dakota's budget. But if the state that received the least federal amount of money said no to Congress in this instance, they would lose at least 10% of their state budget. And according to the court, that's not a real choice. No state can afford to lose 10% of their budget. So therefore, this wasn't a true choice for the states. Moreover, going back to one of those conditions from the Dole test, the court said that Social Security was a New Deal program passed in the 30s under the Roosevelt administration. And it wasn't clear, states who would have agreed to Medicaid at that point in time, it wouldn't have been clear to them that they would have been faced with a choice like this decades later. Instead, the court said the law looks more like the regulations struck down in New York and Prince, where the states are actually being coerced into regulating a federal program while federal officials avoid political accountability. Right? So this looks more like the choice that New York was offered in the New York case. Right? Regulate how we want you to, or take title to radioactive waste. Not a real choice, according to the court for the state here. Regulate like we want you to by expanding your Medicaid program, or lose at least 10% of your state budget. Again, according to the court here, not a real choice. So, drawing this back together, it really is important to appreciate all of the divisions, both the columns here and the row divisions, and I would urge you to study this closely. So the spending and the taxing power, non-regulatory powers, and therefore greater in some sense because Congress can touch on areas that it couldn't directly regulate, right? But on the other hand, they don't bind people. People or states still have a choice when Congress is exercising its taxing and spending powers. And when it turns out not to be a real choice, then those statutes are struck down, like the three things, like Sebelius, the healthcare case under the spending power, or the Bailey versus Drexel Furniture, where a tax turns into a penalty. But because they're non-regulatory, they are not subject to the federalism-based limitations, right? Because if it represents a true choice, then the state isn't being coerced, the state isn't being commandeered. All right, let me end there. This isn't too much earlier than the other classes, but at least it will save us some time, and then if there are any questions, we can discuss them hopefully in person during the Zoom lecture.